Well, good evening, everyone, and welcome back to AJ 102. And tonight's lecture is going to be on Chapter 8, and the subject is going to be policing within the law. Now, the patrol officer is the first interpreter of the law and, in effect, performs a kind of a quasi judicial function. He or she makes the first attempt to match the reality of human conflict with the law. He or she determines whether to take no action, to advise, to warn, or to even arrest. He or she determines whether physical force must be applied, perhaps even to the level sufficient to cause injury or death. It is the patrol officer typically who must discern the fine distinction between civil and criminal conflict, between merely unorthodox behavior and crime, between a legitimate dissent and disturbance of the peace, between the truth and a lie. As the interpreter of the law, the officer recognizes that a decision to arrest is only the first step in the determination of guilt or innocence. He or she is guided by and guardian of the Constitution. Now, that was taken from a task force report, the President's Commission on Law Enforcement and the Administration of Justice back in 1967. But when you talk about policing within the law, you can just look at the climate today in law enforcement and you can see that there are some issues. And now is not the time for me to debate. We can do this on discussion board or something else, the whole issue regarding use of force in police, and we're going to cover some of that. But we want to make sure that we hit the fine points of the chapter before we really kind of chase a bunch of rabbits and get out there. But for this particular chapter, again, I would emphasize that you look on page 280 in your textbook and you go through some of the definitions there, so that way you have a better overall understanding on what some of the things actually mean as we start to talk about them a little bit more in this chapter. So this chapter is going to begin with a brief look at this interesting word called discretion as it pertains to officers' abilities to use force within the law, and then turns to the Fourth Amendment, which governs searches and seizures. This is going to be followed by an explanation of the police-citizen contact continuum and the objective of voluntary contacts. And we'll talk more about that too, these consensual or voluntary contacts. Next, we'll talk a little bit about the Terry stop. So we'll discuss that, as well as the constitutionality of roadblocks, checkpoints, when a suspect may be lawfully detained. And finally, we'll examine lawful searches, lawful arrests, including what they call de facto arrests, and discuss the importance of protecting the suspect's rights. And we'll specifically look at a case, if we have time, the Miranda warning. But again, that's why it's very, very important that you take a look at a lot of the definitions and read the chapter as well. So by way of introduction, government agents, including police officers, are subjected to certain restrictions enforcing the laws because we all have guidelines that we work by. Law enforcement will not only have constitutional guidelines, legislative guidelines, and what have you, they'll also have what we call in policing policies, procedures, and general orders. So there are additional internal guidelines that they will have to work within as well. So it really is a little bit more difficult than it looks. Police officers must know the law. Well, while that might seem like a pretty straightforward statement, it really is. I mean, because the law is becoming so much more complex, we really do need to know the laws as as deep as we can. Any violations of the law can result in evidence being disallowed, basically meaning that if you obtain something outside of the scope of whatever boundary or law that you're supposed to maintain within, then you could end up with evidence being disallowed later on down at trial, or perhaps even before trial. And officers need to know their own state's laws and precedent cases, as well as those emanating from the Supreme Court. So we talk about case laws, those precedent cases that have set a certain standard in a certain case, kind of like the Miranda warning, and we'll talk about that a little bit later on in the chapter. So as we start to get into this chapter, I want to begin here. Decency, security, and liberty alike demand that governmental officials shall be subjected to the same rules of conduct that are commands to the citizens. In a government of laws, existence of the government will be imperiled if it fails to observe the law scrupulously, meaning like paying attention to it very fine. Our government is the potent, the omnipresent teachers, if you will. For good or ill, it teaches the whole people by its example. Crime, in essence, is contagious. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man or woman to become a law unto themselves, meaning that at some point it will invite anarchy. Now, I know that's kind of a way out there statement that I kind of went through, and it might sound a little bit, something you might hear on TV or at some speech, but really, when you boil this down, what I just said is that, in order to properly enforce laws, we need to make sure that we maintain and obey the laws ourselves. So that is something that's really, really important. And a fine example would be this, and it's going to seem kind of maybe a little low level, but I think you'll get what I'm saying. So let's say you're a police officer and you're out working traffic and you're writing all these tickets for, let's say, window tinting. The unauthorized use of window tint on the front windows, and I'm not going to go into how bright or dark or where it can be and all that stuff like that. But so you're citing people for window tint violations, yet on your car, you have the same type of tint. So how can that show a level of equality, if you will, to where you're actually violating the law yourself, but you're out there writing people tickets for the same thing that you're violating? You see, hopefully that kind of makes a little bit of sense. So the bigger picture when we talk about this chapter is going to be this word called discretion. And although our Constitution guarantees to all persons equal protection under the law, police officers can and do exercise discretion in how they apply the law. They select options on what actions to take under certain circumstances. And to kind of give a quote from Chief Justice Warren Burger, once stated, "The officer working the beat makes more decisions and exercises broader discretion affecting the daily lives of people every day, and to a greater extent than a judge will exercise in a week," meaning that officers are out there contacting people all the time. Therefore, they're going to be using discretion all the time. And the myth out there is that police always have discretion in determining whether to issue a citation or arrest somebody. And the reality is that sometimes they don't. There are many times when the police don't have any discretion in the matter that they're enforcing. So one example could be an incident involving a court order issued by a judge or a magistrate. If that order is in violation and it states that an officer shall arrest a person, the officer is basically obligated to enforce that court order or be subject to contempt of court. So there are some things, we have discretion, but there are times where we don't. So research by a couple of authors, Stroschein, Albert, and Dunham back in 2008 examined the informal working rules that govern police behavior and affect their discretionary decision making when determining when to stop, search, or arrest a suspect. Among the working rules the researchers identified were the following, and here's kind of a list of some of them. The importance of time, place, and appearance. Officers look for things that don't fit. So remember, we're talking about determining, okay, using that discretion that we have, determining when to stop, search, or arrest. So the importance of time, place, or appearance. So if it's late at night, in the middle of the night, and somebody comes out from behind a building, think in your mind, maybe the person might not be doing anything, but if all those buildings are closed and it's dark and burglaries happen at those times of the morning or evening, doesn't it seem, I guess a good word would be fair or appropriate, that the officer would find out why that person came from behind that building? And you would want them to do that if they were patrolling in your neighborhood in the middle of the night, somebody walked out of your backyard. So let's kind of try to put this in context as we go through these. So next, do unto others, meaning being fair. Officers would not take action if they engaged in the same behavior themselves. For example, not wearing a seatbelt. So I kind of went through that with the window tint. So if you're out there, you shouldn't be writing tickets for no seatbelt if you don't wear a seatbelt. Make sense? The next one is threshold. Stopping only individuals who exceed a particular limit, for example, speed limit. So, if you're working traffic in an area and let's say the speed limit's 45, but you're not going to stop people going 47 or 48, so maybe you set your threshold at maybe 55. So if they're exceeding by 10, then you're going to make the stop. So you can see they have that level of discretion in there. And then the last one we're going to kind of cover here is kind of interesting the way the book puts it, but they call it POP, or pissing off the police. Suspect demeanor influence officers' response to citizens. Leniency might be afforded to the person who treat the officers with more respect, whereby the heavy hand of the law is extended to persons who are disrespectful, ill-mannered, or rude. So let's just say that you're the officer now. I'm going to put you in this spot for a second. You make a traffic stop on someone, and you walk up, and the person says, and the person cusses at you and says, "Why the F did you stop me?" Okay, do you not think in your own mind as a human being that right away you're going to be a little bit defensive and go, "Well, I stopped you because of whatever"? I mean, you see where I'm going with this, right? The person is kind of jumping on you, questioning everything you're doing, versus maybe the person that says, "Good evening, officer. I'm not really sure what I did wrong. Could you tell me?" And you tell them, "Hey, you were speeding." And they say, "Well, I'm very sorry. I didn't realize I was speeding." Who do you think you'd give the ticket to? And I'm just going to kind of leave that statement hanging out there and give you a chance to kind of let that soak in. In situations where officers use discretion, their professional judgment, to choose from alternative courses of action, there is no liability unless evidence indicates the officer was guilty of a willful or malicious wrong. However, when there is no discretion, when officers are faced with a fixed, certain, and imperative policy, there's no immunity. So if the policy says that you're supposed to arrest and you don't, if the law says that you're supposed to arrest and you don't, the officers don't have immunity. So that's why under some circumstances they need to make arrests, and sometimes we as citizens don't understand that. Although officers have broad discretion, they are guided by several constitutional amendments and the holdings of the Supreme Court related to some of these amendments, and we'll talk about some of them as we move on. And we're going to try to squeeze all this in about 50 minutes, so just bear with me as we move through a lot of these. But I do need you to go through and read the amendments, read the Bill of Rights, the first 10 amendments, and then throw in the 14th Amendment for fun. Okay, so go through those. You can even Google them just to get an idea of what those are, because you might see some of those on a test at some point. So the Fourth Amendment, the right of the people to be secure in their homes, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So the constitutional standards for searches and seizures, including arrests, are contained within this Fourth Amendment, which requires that searches and seizures be reasonable and based on probable cause. The terms reasonable and probable cause provide a very fine but significant weight to balance the scales of justice, which measure the conduct of all people. Without what is referred to as probable cause, the laws that govern us might easily become unbalanced, that is, too permissive or too restrictive. The second part of the Fourth Amendment, called the Warrant Clause, states that no warrants shall issue but upon probable cause. In other words, all warrants, search warrants and arrest warrants, have to be based on probable cause. So a couple of quick definitions that we kind of want to make sure we hit. Again, the first one is reasonable. So what is that? The rules determining what constitutes a reasonable search or reasonable seizure result from the interpretation of the first part of the Fourth Amendment, called the Reasonable Search and Seizure Clause. That kind of makes sense. Which states in part the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Reasonable means sensible. It means justifiable. It means logical. A key determination or determinant in whether an officer's actions are lawful is whether the officer has reasonable suspicion that criminal activity is occurring. So you can't just like walk up and arrest somebody because you have a hunch, okay, or detain people because you have a hunch, or search them because you have a hunch. And we're going to go through some of these terms later on, and we're going to talk about reasonable suspicion and probable cause and totality of circumstances, and we'll get a little bit more into that. But you know, that reasonableness, when you can look at the slide right here, it does talk about it's the totality of circumstances. So meaning considering all the factors involved in a given situation. That's what will make up that reasonable suspicion. So here it is. Reasonable suspicion, a legal standard defined in United States versus Cortez, that's the case law, as, quote, a particularized and objective basis for suspecting the particular person stopped of criminal activity. Okay, so that's kind of where that reasonable suspicion comes in, and I gave you a little bit more earlier. So now we can move on to probable cause, and there's a couple of things to look at here. The concept of probable cause is one of the oldest and most important in criminal law, having existed for more than 2,000 years and occurring in both Roman law and the common law of England. In the case Draper versus United States, 1959, the Supreme Court stated, probable cause exists where there are facts and circumstances within their, meaning the arresting officers, knowledge and of what they had reasonably trustworthy information are sufficient in themselves to warrant a man of reasonable caution in the belief that an offense is being or has been committed. So, and I'll give you a different definition in a minute. Smith versus United States, 1949, defines probable cause as the sum total of layers of information and the synthesis of what the police have heard, what they know, what they observed as trained officers. We, the courts, weigh not individual layers, but the laminated total, and that kind of seems like a whole much out there. So probable cause, again, by book definition, okay, reasonable grounds for presuming guilt, facts that lead a person of ordinary care and prudence to believe and consciously entertain an honest and strong suspicion that a person is guilty of a crime. Okay, that one's a little bit easier to kind of understand. Now, probable cause may be based on a couple of different things. There's actually 4 things here. Observation by officers, expertise of the officer, circumstantial factors, and information communicated from officers. So we're going to touch on these real quick, and then we're going to have to keep on moving. So observational probable cause is what officers see, hear, or smell. That is, evidence presented directly to the scene. This is similar to eyewitness testimony, and of course is the strongest form of probable cause, because the courts have recognized that certain types of events as being significant in determining probable cause. But if you see something, then and you witness it, well, it's kind of hard to dispute that. Suspicious activities contribute to probable cause. For example, a car being driven slowly can be suspicious when, let's say, A, the car has circled the block a bunch of times, B, the people in the car are watching or looking at a building as they slowly drive by, or C, the building is closed for the evening, or D, the building is located in a high crime area. So you put all those four factors together and you could probably come up with some probable cause. Next, expertise and circumstantial probable cause. Expertise and circumstantial probable cause are often tied to observational probable cause. Police officers' experience and knowledge of criminal traits and their ability to put the pieces together like a puzzle may also contribute. So your expertise will also formulate some probable cause. Next, informational. Informational probable cause covers a wide range of sources. In the case previously described, the information about two suspects forwarded by the police to the nearby town constituted informational probable cause. The major categories of informational probable cause are officer sources, victims of crimes, informants, and witnesses. So, all of these things can establish probable cause. Also, official sources, police bulletins, broadcasts over the radio, information that you get at roll call, all of those things are contributing towards that informational probable cause area. So now we're going to kind of move into some of the stops, that police-citizen contact continuum. And if you look on page 286 in your textbook under figure 8.1, I'm not going to go through this whole thing here, but I'm just going to kind of touch on a few things because, time is kind of the essence for this chapter. So police officers interact with citizens on several levels. On the first level, the voluntary contact levels, officers asked to talk with a person to gather information about a crime, for example, a door-to-door canvass following a shooting or a murder. Officers do not suspect the person of involvement in the crime, but basically they're just asking people and kind of talking to them. At the next level is a situation when an officer might suspect a person to be involved or is about to be involved in criminal behavior and basically stops the person to talk to them. Now, if that person believes that he or she is required to comply, this is, in effect, a stop and requires reasonable suspicion. If during the talk the officer observes some behavior and then develops that reasonable suspicion or learns information giving officers probable cause to believe the person is in fact involved in a crime, then they can detain the person a little bit longer and investigate that crime a little bit further. But this diagram kind of shows you what the officers can and can't do. So again, I'm not going to go through the whole thing. I'm going to let you do it. But officers a lot of times will do what they call a voluntary or consensual encounter, meaning that they will approach somebody and they'll have an interaction with them, and it may go something like this. Hey guys, what's happening? And then maybe they answer, hey, nothing, officer. Well, where are you headed tonight? Well, we're going over here. You mind if I talk to you for a minute? Yeah, that's okay. That's a consensual contact, okay? So the people pretty much, the officer asked the question, do you mind if I speak to you for a minute? The person consented, therefore, you can go ahead and talk to them. Now, at some point, if they decide, hey, I don't want to talk to you anymore, they do have the right to leave unless, of course, the officer now has some type of reasonable suspicion. Okay, so when that happens, then they can detain the person to investigate further. And then if they develop what they call probable cause, which is a level higher, then they can make an arrest on somebody. So that's kind of how that goes. So Again, we'll go through this a couple of times just to make sure that you have it, but look at that diagram on the page. So voluntary contact is a worthy objective when interacting with citizens. The key to creating a voluntary contact is to request cooperation in a manner that suggests an option, or simply to strike up a normal, non-coercive conversation. So looking at the examples that I gave you, the officer's words, how they say it, is very, very critical. So let's look at, as we start to go on, a couple of definitions here, and then we're going to talk about the Terry stop as well. So let's see here. Okay, so we're going to get a little ahead of ourselves. Along with the police-citizen contact continuum, I want to kind of show you something. We talked about the officers when they see things. This slide that's showing up here right now talks about some things that the officers can do to develop more reasonable suspicion or even probable cause. So plain view allows the seizure of apparent criminal items seen with lawful access. So plain view, like you see it out there in public. Plain feel, where an item is felt during a lawful touching or pat down search and is immediately apparent as contraband or a weapon. You can basically retrieve it. So let's say I do a consensual contact. Hey, where are you going? Nowhere, officer. Hey, it's kind of late. You're walking around. Just want to make sure you're not out up to anything, up to no good. So you mind if I check you for weapons? The person says, no, go ahead. And you start to pat them down and you feel a hard object that feels like a gun. Okay, you can detain somebody and remove that item for that. So that's the plain feel. Plain smell, both officers and trained dogs can use the sense of smell to detect the presence of seizable objects, meaning so if they're smoking weed or something like that. Plain hearing, conversation carried on in the presence of an officer or informant can be lawfully overheard. And then plain shape, containers can be opened where their outward appearance reveals criminal content. So all of these things kind of lend itself towards this police contact continuum. So I'm backing up a little bit here. We talked about this voluntary contact and, reasonable suspicion to detain a person to investigate further in the arrest on probable cause. We've gone through this progression, or I've given you some definitions on plain view, feel, smell, hearing, and shape. Again, the voluntary contact is requesting cooperation, and we've kind of ran through this one already, and then we're going to move now into what we call the Terry stop. So one basic responsibility of police officers, and one heavily reliant on reasonableness and probable cause, is investigating suspicious behavior. Officers may simply talk to someone acting suspiciously and decide no crime seems to be in progress or about to be committed, or they may confirm their suspicions and investigate further. The simple act, however, of stopping someone based on reasonable suspicion may lead to a stop, alternately called an investigative stop or a field inquiry, a threshold inquiry, or more commonly known as a Terry stop, and then I'll define that in a second. So a stop, briefly detaining someone who is acting suspicious. A stop is not an arrest. So the mere fact you stop somebody doesn't mean you're arresting them. An investigatory stop, the simple act of stopping someone based on reasonable suspicion, alternately called a field inquiry, a threshold inquiry, or most commonly referred to as a Terry stop. Field inquiry, briefly detaining or stopping someone to determine who they are and kind of what they're doing. And then the Terry stop, the simple act of stopping someone based on reasonable suspicion, alternately called an investigatory stop, a field inquiry, or a threshold inquiry. So again, all of these things they're all woven together. So, but under the Terry stop here, we know it's an investigatory stop or a field inquiry. It's based on the case law Terry versus Ohio in 1968. Requesting identification, which you can do. The plain view doctrine is in effect, meaning if you see things in plain view, of course you can take them. And then the plain feel or touch doctrine is also there. Now, really quick, I'm not going to go through the Terry stop. On page 287, I'm going to have you go down under Terry stop, and then from, say, paragraph 2 down to, so read paragraph like 2 and 3, and you'll kind of see what the Terry stop really involves. But the issue, it is always unreasonable for a police officer to seize a person and conduct a limited search for weapons unless there is probable cause for arrest. That's the issue. So, I mean, and that was a question. That wasn't me giving you a simple statement. So you can, if you believe that somebody is armed, conduct a pat-down search, that Terry search, okay, for weapons. And if you feel something that feels like a weapon, you can detain, you can seize that weapon, and you can arrest that person. So I'm trying not to confuse you, but I want you to go through that information on the Terry stop so you have a kind of a better understanding on what it is. So I used a couple different words in there, seizure, pat down, and a frisk. So let's kind of define those. The Supreme Court in Terry versus Ohio said there is a seizure whenever a police officer uses physical force or a show of authority to restrain an individual's freedom or to walk away. And there is a search when an officer explores an individual's clothing, even though it is called a pat down or a frisk. A stop is a seizure if physical force or a show of authority is used. A frisk is a search. So if I see you and instead of saying, excuse me, do you mind if I talk to you for a minute? And then you respond with, yeah, not a problem. If I say, hey, you stop, and then I walk up and start talking to you, that in essence, that's a seizure as outlined in the Terry versus Ohio case that was defined by the Supreme Court. So because of authority. Didn't necessarily mean that I grabbed you, but there's the authority thing. A pat down, an exploratory search of an individual's clothing, the search phase of a stop and frisk. So when you stop and frisk, that's the search part of it. A frisk is a patting down or minimal search of a person to determine the presence of a dangerous weapon. So stop and frisk, here's this whole thing put together, is a protective search for weapons in which the intrusion must be limited to a scope reasonably designed to discover guns, knives, clubs, or other hidden instruments that may be used to assault police officers or others. Terry, that case, Terry versus Ohio, established that the authority to stop and frisk is independent of the power to arrest. A stop is not an arrest, but a seizure within the meaning of the Fourth Amendment, and therefore requires reasonableness. So there we're back to that word, reasonableness again. So go through some of these things that are written in here. There's a case, Pennsylvania versus Mims on page 289. There's another one, Maryland versus Wilson on page 289. I'd like you to take a minute there and kind of go through those, and it's a little bit more information on Terry versus Ohio and things like that. So let's see what else we have. So we've gone through all of the Terry versus Ohio information, requesting identification, and this is kind of a myth as well, so let me kind of go through this. The Supreme Court has ruled states can criminalize a refusal to provide identification to an officer conducting a valid stop. In June 2004, the Supreme Court ruled in Hibble versus 6th Judicial Court of Nevada, Humboldt County, that police may require persons to identify themselves unless their names would be incriminating. So here we are, we can ask for ID, and if you're in a vehicle, you do have you are bound to where you have to produce identification. Plain view, we talked about that. Under that plain view, plain feel, touch thing refers to evidence that is not concealed. So that's pretty much a pretty easy one for us to kind of understand. So let's kind of move on now to roadblocks and checkpoints. We're at about 34 minutes, so we're going to see how much more of this we can kind of knock out. So the types of different checkpoints, roadblocks that are out there, there's border checkpoints, sobriety, informational drug, and then general crime control. And we'll kind of walk through a few of those really quick. Border checkpoints, because they serve a broad social purpose, have been declared constitutional. In the case United States versus Martinez/Fuente, 1976, the court affirmed that a vehicle may be stopped at a fixed checkpoint for a brief questioning of the occupants, even though there is no reason to believe the particular vehicle contained illegal aliens, but because of the roadblock exception here. And you've seen those as you've driven in from sometimes different parts of the country, where you'll see the Border Patrol agents that are conducting checkpoints. So those are valid. Sobriety checkpoints, serving the broad social benefit of protecting motorists from drunk drivers, are another form of stop that have been declared constitutional, providing they are conducted fairly and they do not pose a safety hazard. Now, you can't just do driver's license checkpoints, okay? That's why they used to do driver's license / DUI checkpoints. Now it's strictly sobriety. And if you're driving a motor vehicle, you do by law have to present your identification or your license. So that's an easy way to be able to kind of fit in both of those pieces. So that's something that you can do as well. Informational roadblocks have also been declared constitutional. Illinois versus Lidster, 2004, allowed roadblocks to be used when police are merely seeking witnesses who may have information about crime. So the Supreme Court has upheld roadblocks at national borders, sobriety checkpoints, and informational checkpoints. But what about, let's say, the last couple on here, drug and general crime control? Drug checkpoints have been found to violate the Fourth Amendment. So in the case of City of Indianapolis versus Edmond in 2000, the Supreme Court deemed drug interdiction roadblocks an unconstitutional means to a valid law enforcement end. So, can we still, are there still people out there that work the highways and basically do drug interdiction and profile vehicles and use valid traffic stops and canines and things to arrest drug transporters and things? Sure, they do, but simply a drug checkpoint and checking every car as they go through is something that we can't do. This ruling makes general crime control checkpoints unconstitutional as well. In addition, and I talked about that a minute ago, driver's license checkpoints simply unto themselves are not permitted. Thus, the Fourth Amendment's reasonableness standards keep officers from randomly stopping vehicles to check for driver's licenses and registrations. There needs to be another violation or something. So, again, just to reiterate, the Supreme Court has held that drug checkpoints, general crime control checkpoints, and driver's license checkpoints are not constitutional. Now, you can also do a checkpoint. Let's say that you're passing out flyers for a kidnapping victim and you want to make sure that you're getting the information out or being able to retrieve information from other people. You can set up an informational roadblock for something like that to pass out those flyers, and I think I mentioned that earlier. So those are the types of roadblocks and checkpoints. So now let's move on to this word called detention. We've talked about discretion and probable cause and reasonable suspicion and things like that. So a detention occurs when an officer has said or done something that would cause a reasonable innocent person, okay, listen to the words, reasonable innocent person, to believe he or she is not free to disregard the police officer's presence and go about their business. A detention must be justified by reasonable suspicion of criminal activity on the part of the detainee. Under this standard, it is counterproductive error for officers to speak of probable cause for the stop. Probable cause is never constitutionally required for detention. So a lot of times, what they're trying to say here is that officers a lot of times say, well, probable cause for the stop. Well, you don't have to have probable cause. For a stop, all you need is reasonable suspicion of something happening. So let's say that there's a robbery at a liquor store at 123 Main Street, and the person is wearing a black jacket, blue jeans, white tennis shoes, holding a brown bag. And 30 minutes later, you're driving around and you see a person that matches the description with a black jacket, blue jeans, white tennis shoes, and he's holding a brown bag. And he's in the general area of where the robbery occurred. Think about that. Would a reasonable person, based on the information that you have, form the conclusion that that could be the person involved in the crime? The answer would be yes. Therefore, you would have reasonable suspicion to believe that that person may have been part of that criminal activity. Therefore, you can stop them. Does that make sense? So, I mean, that's kind of one example there. A Terry stop generally takes one or of two paths. It either progresses into probable cause to arrest, or it fails to develop that probable cause and requires the person's release. However, reasonable suspicion authorizes the police to detain a suspect while they investigate the relevant suspicious circumstances, meaning that if I have reasonable suspicion to stop you, I can, under a reasonable time frame, work on my case a little bit and developing a little bit more probable cause, so I can talk to some people, look at some evidence, or whatever it is. And I can't keep you out there forever, hours and hours, but I do have the ability to, kind of build my case a little bit. But if your case starts to drag on and you can't really develop any probable cause, you may have to let the individual go. So if a Terry stop lasts too long, courts will rule that basically an arrest had occurred, which of course requires a higher standard of probable cause. So you can't arrest for reasonable suspicion. You see what I mean? So as such, courts have generally held that investigative detentions are to be resolved within a time frame measured in minutes, not hours. So, is there an exact minute? No. Okay, there really isn't. Now, in the textbook, it's going to talk about a couple of different places, whether it says, prolonged periods being, 60 minutes, 90 minutes, or whatever. It's based on the facts of the case. Remember, the totality of the case. So if you're starting to build your case on reasonable suspicion, you can take a little bit of time to get up there, but it really needs to be more in the realm of minutes than it does in hours. So now we're going to look a little bit more towards lawful searches. And let's see where we at. Time 42. Okay, we'll see if we can kind of squeeze this in. So a search in the context of the Fourth Amendment involves governmental invasion of privacy. Searches are intended to obtain incriminating evidence, right? Okay, but they must be justifiable. I mean, you can't just stick your hand in somebody's pocket. The principal justifications established by the courts for the right to search are when, and I'm going to give you kind of a list here, a search warrant has been issued. So if you get a search warrant from a judge, well, you can search. No warrant has been issued, but you have consent, meaning that you ask a person if you can search, and they say yes. There's what they call exigent circumstances, meaning that some type of emergency circumstances exist, or there's no exception of privacy and thus no requirement for a search warrant. These circumstances are kind of the preconditions for a reasonable legal search. So real quick, a search warrant is an order issued in writing or over the phone by a judge or a magistrate with jurisdiction in the area where the search is to be made. And I'm going to let you kind of read a little bit more on that. The affidavit part of the search warrant is a statement reduced to writing and sworn to before the judge or a notary having authority to administer an oath, meaning when you do a search warrant, when it's all said and done, you swear to that search warrant to the judge, and you'll sign that, and they'll sign it, and it'll be stamped and dated and everything, because you're basically swearing that what you saw is true. So searches conducted with a warrant they're going to need an affidavit that I just kind of talked about, that statement, and you're going to have to list what kind of contraband that you're looking for. And we'll go through what a search warrant contains, either in the end of this chapter or later on. Searches without a warrant, again, we talked about emergency or exigent circumstances, and there are some limitations on searches when it comes to what you can and what you can't do. So we'll kind of go into a little bit more on that, and we'll see if we can. Yeah, it's going to take a little while. All right, we're going to try to get as much as we can. So I'm going to give you some definitions as we kind of look through here, through the book. We're going to talk about, we talked about what you're searching for, which would be contraband, which is anything illegal to import, export, produce, possess, like, heroin or a machine gun. Those could be a couple of things that would be deemed as contraband. The courts have this other phrase out there that talk about, when your search may not be lawful, and it's called the exclusionary rule. So a U.S. Supreme Court ruling that any evidence seized in violation of the Fourth Amendment will not be admissible in a federal or state trial, meaning that if you seize something illegally, that stuff is not going to be admissible. So again, just to kind of go through that, because this is really important, any evidence illegally seized by police will be considered tainted and thus inadmissible in court, regardless of how relevant it is to proving the suspect's guilt, through application of, again, the exclusionary rule. By extension, however, keep this in mind too, any further evidence obtained from the initial illegal search or seizure will also be deemed inadmissible via what they call the fruit of the poisonous tree doctrine, which is a metaphor to explain that a tainted source of evidence, the tree, and anything it bears, the fruit, are unconstitutional. And these rules exist to deter police from taking illegal means to achieve a just end. So hopefully that kind of makes sense to you a little bit too. So lawful searches, we may not have time to get to all of the different types of searches there that are going to be listed here. Police officers are usually required to announce their authority and purpose before entering a home. In the case Wilson versus Arkansas, 1995, a unanimous Supreme Court held that without emergency circumstances or exigent circumstances, officers are required to what they do call knock and notice or knock and announce to meet the reasonableness requirement of the Fourth Amendment. Such a requirement protects citizens' right to privacy, reduces the risk of possible violence to both police and the occupants, and may prevent unnecessary destruction of private property. Law enforcement does, after they announce, however, if they are refused entry or no one comes to the door, they can still force entry, meaning they can use a key or they can forcibly open the door. And you've probably seen it on TV before with like a battering ram or something like that. So those are some of the things that they can, basically, that we can do. So again, as we start to kind of go through some of these things, and I want to make sure that I hit some of the definitions in the book, we talked about warrantless searches with consent. The Supreme Court has ruled that a search conducted following lawfully given consent is an exception to the warrant and probable cause requirement of the Fourth Amendment. In a search where consent is given, the consent must not be given in response to a claim of lawful authority by the officer to conduct a search at the moment, meaning you can't say, hey, either you let me search or I'm going to go to a search warrant. So that's kind of coercive. It has to be more to agree, to give permission, voluntarily oral or written permission to search a person or their property. And that person can also retract that statement of allowing somebody to search too. So if they give you consent to search and you're in there searching and then they withdraw consent and, I decided after you've gone through half the house, I'm not going to let you search anymore, they can lawfully do that. We talked about the definition of emergency circumstances. Fresh pursuit is another one that's in there, is the right of police officers to make warrantless or make a warrantless search of a fleeing suspect, or to cross jurisdictional lines or boundaries that would otherwise be restricted to arrest a fleeing subject. And so that would be a case where if somebody jumps out of a car and the officer is chasing them on foot, and they run up to their house and they slam the door, and the officer is going in at the same time when the door is slamming, because of the fresh pursuit, the officer would not need a warrant there, okay, to go into the house. Now, once he detained that person in the home, he would in fact, or she would in fact, need a warrant to search the rest of the house, okay, but not to make the arrest of the person there. So when they make the lawful arrest, there are going to be some guidelines that are on there as well. So there's a couple of case laws that are important for us to recognize here. So let's say that somebody does, run into their house, and you chase them down, and you make that lawful arrest. Well, what can you do now? So in a search incidental to a lawful arrest, the search must be made simultaneous with the arrest and must be confined to the immediate vicinity of the arrest. And that's the Schimel versus California case in 1969. Example, in Schimel, officers went to the suspect's home with a warrant to arrest Schimel on a charge of burglarizing a coin shop, told him they wanted to look around. The officers opened kitchen cabinets, searched through closets, looked behind furniture in every room, and even searched the garage. Before this case, the course had accepted extensive searches incidental to an arrest. The officers had Mrs. Schimel open drawers and move contents so they could look for items removed in the burglary. The search took nearly an hour and turned up numerous stolen coins. Schimel was subsequently convicted in a California court, but appealed his burglary conviction on the grounds that the coins had been unconstitutionally seized, and the court determined when an arrest is made, it is reasonable for the arresting officers to search the person arrested in order to remove any weapon that the latter might seek to use in order to resist or aid an escape. It is entirely reasonable for the arresting officer to search for and seize any evidence on the arrestee's person in order to prevent or concealment or destruction, and the area from within the arrestee might gain possession of a weapon or destructible evidence. So basically meaning immediate control. So we're going to say all of that, and I know it sounds like a bunch of mumbo jumbo, but we're going to say that to say immediate control. In the Schimel case, the Supreme Court specified that the area of search can include only the arrestee's person and the area within his or her immediately control. The court defined immediate control as being that area within the person's personal reach or wingspan. So those are some of the limitations on there. However, we're going to throw in this word protective sweep, a quick and limited search of premises incident to an arrest and conducted to protect police officers or others. So if you make an arrest in a home and you believe somebody else might be hiding in there, or let's say it's a fresh pursuit case, like you chase somebody in there, or you hear somebody screaming into a house and that's an emergency and you enter, you can visually look into the larger portion of the rooms to make sure that nobody is hiding there. You can do a protective sweep, but if you want to go any further than that, okay, you're going to have to get consent or a search warrant or something else. You can't just kind of jump right in there. So lawful arrests, and we're coming up on the 53-minute mark. We're going to try to see if we can get through some of this. We'll see how we can kind of do. So an arrest warrant, you can make an arrest with an arrest warrant. Arrest without a warrant would be somebody that commits a public offense. So if they commit a crime in front of you, then you can do that. The last two pieces that I want to kind of see if we can hit on. Laws of arrest are generally uniform in all 50 states and in federal and criminal procedures. Statutes throughout the United States generally define arrest as the taking of a person into custody by the actual restraint of the person or by his or her submission to the custody of the officer so that he or she may be held to answer for the public offense before a judge. So again, there's the public offense. Now, the four elements of a criminal arrest are, and I think those were back here, maybe they weren't. No, they weren't. So let's see if we can. 4 elements of a criminal arrest are an intent by an officer to make an arrest, the authority to arrest, a seizure or restraint, and an understanding by the person that he or she is being arrested. Arrest warrants we already talked about. All states have a statute authorizing law enforcement officers to make arrests, but the Constitution stipulates that lawful arrests require an arrest warrant. From a practical point of view, police officers should obtain warrants to protect themselves against civil liability for false imprisonment in case it is later determined that the arrest is unjustified. Like a search warrant, an arrest warrant requires that affidavit I talked about earlier, stating the facts, supporting probable cause, and sworn by the officer. But now you don't need an arrest warrant if you observed a criminal act in your presence, a public offense in your presence, any crime, including felonies or misdemeanors. So, moving on now, the right to resist. Sometimes when an arrest is made, the person being arrested resists, and the officer must use force to make the arrest. This is going to be discussed a little bit more in Chapter 11 as we kind of get further into the book. It should be noted here, however, that American courts adopted the common law right to resist arrest until about the mid-20th century. The trend during the past 50 years has been to eliminate that right. The decision whether to continue to eliminate that right rests on the degree to which we value liberty rather than order. But at the end of the day, I can tell you that if you are given a lawful directive by a police officer, the way to eliminate any issues would be is that you go along with the directive. And if you believe that the officer was incorrect, there are ways that you can bring that up, whether it's in court on your case or through the complaint process through a police department. But you just to arbitrarily resist an officer based on a lawful order that you've been giving, that's not going to work for you. You're going to get arrested and you're going to get convicted for resisting arrest. So I think that's a misnomer. It's a myth out there that you can just like resist arrest because you don't believe or agree with what the officer is doing. That is incorrect. Okay, regardless of, what anybody else might tell you. So let's move on real quick. A de facto arrest, though, I want to make sure we get that in, occurs when an officer who lacks probable cause to arrest takes a suspect in for questioning. Officer's actions have the appearance of an arrest, that is, the suspect is not free to leave. So, again, it occurs when officers lack probable cause to make an arrest. You take them in for questioning, and then you kind of change your mind or what have you. Now, if you have to read the person their rights, too, if you're going to actually, if you believe you're going to arrest them or you're questioning about something and they're actually detained or arrested, you're going to have to read them their rights. And that leads us into this Miranda thing. And we're going to kind of end with this because we're really starting to run out of time. So Miranda versus Arizona, 1966, 4 specific rights here. And I'll kind of read you what the warning says. So you have the right to remain silent. If you give up the right to remain silent, anything you say can and will be used against you in the court of law. You have the right to speak to an attorney. And you have the right to have an attorney present during any questioning. If you so desire and cannot afford an attorney will be appointed to you without any charge before questioning. And then, do you understand each of these rights I've read to you? Having these rights in mind, do you wish to give up your right as I have explained them? And talk to me about this case. So that's kind of the Miranda case. Before interrogating any suspect, police officers must give what we call the Miranda warning as established in Miranda versus Arizona. The Supreme Court asserted that suspects must be informed of their rights to remain silent, to have counsel present, to state-appointed counsel if they cannot afford one, and to be warned that anything they say might be used against them in a court of law. Many investigators carry a card that basically has the Miranda warning on it, and they read it before they interrogate someone. So I'm not going to go into the entire Miranda case, but I'll have you kind of read that yourself. It's on page 311 and 312. So a myth, if you're arrested by the police, they must read you the Miranda rights. They have to read you your Miranda rights. Actually, they don't. Okay. There's two components there. Okay. It's interrogation and custody. So if they detain you for a crime, or even if they arrest you, okay, if they're not going to question you, they don't have to read you your rights. Now, we like the officers to do that because it just covers them, okay? But again, so the two terms that are key in this situation, interrogation and custody. If they're not in custody, you can interrogate them. Does that make sense? The circumstances involved in a interrogation and whether it requires Miranda warning were explained in the case of Oregon versus Matheson, 1977, and that's on page 313. And I'm not gonna go through that one as well, but I'm gonna have you take the time to kind of reading that. Now, somebody can waive their rights. So if they decide that they want to talk, so suspects can waive their rights against self-incrimination and talk to the police officers, but the waiver must be voluntary and preceded by the Miranda warning. The suspect must fully understand what rights are being given up and the possible consequences. So we need to make sure that, you know, they know exactly what is going on and what they're going to give up. So let's see, protecting a suspect's rights, the Miranda warning before interrogation. I'm going to let you kind of look at a couple of those. I'll cover one, though. The public safety exception allows police officers to question suspects without first giving Miranda warning if the information sought sufficiently affects the officer or the public safety. So this was a case, New York versus Quarles. It's Q-U-A-R-L-E-S. Supreme Court announced that in certain cases, police may question suspects in custody without first advising them of their rights not to incriminate themselves based on this type of emergency, public safety, or officer safety. So this kind of went a little bit longer, and I didn't mean for it to go all the way, but again, I'm going to have you fill in some of the blanks by looking at your textbook and making sure that you're filling in some of the holes there. So in summary for this chapter, probable cause requires more than mere suspicion. Stop and frisk is a form of search and seizure. Supreme Court has upheld roadblocks at national borders, sobriety checkpoints, and informational checkpoints. U.S. citizens are protected by or protected against unreasonable arrest or seizure by the Fourth Amendment, and the Miranda warning contains 4 specific rights, and those are the ones off the card that I read. So that's going to be the end of this particular chapter. And if you have any questions, go ahead and just post them on the general discussion board. So until next week, thank you very much.